I do not feel I'm influenced by them. And I think I'm able to give both parties or all parties a fair and honest hearing.
Mr. Chairman,
Yes.
am I allowed to show these to my clients?
Oh, absolutely. Absolutely. Yes. And if you want to step out in the vestibule and chat with them, go right ahead.
I think they can read them.
Okay.
And then I'll pass them to disposal.
Very good. And for the record, these 5 emails are the only outside communication of any kind I've had with anyone about this case.
That's it? Yeah, that's it.
Those are the,
These 5?
yes. If you finish looking at it, just give it to Ms. Hughes. All right. Does either party have any objection to my serving on this panel?
May I ask some questions?
Just, I don't want the others
Yes, sir.
to be tainted by the content. So if you'll stay away from that, of course you can.
Yes, sir.
Sure.
If we had an objection, I'm not saying that I have an objection, I'm just trying to figure out what my position would be. That would leave 3 members. Is that enough to have, is that a quorum to have a hearing?
If you object, then the board, without me, the other 3, they vote as to whether I should come off or not. It's up to the other 3 board members.
Yes, sir. And if they chose to not have you hear this, it would that destroy our ability to have a hearing?
No, my understanding after
I don't know how many members of your board exist.
5. And my understanding from this lovely little book written by the UNC Institute of Government is, yes, you could have a 3-person appeal hearing,
Okay.
but all 3 would have to agree. A majority of what the standard 5-person board, and that's 3, that have to all agree. So that's my understanding.
But man, well,
Absolutely.
yeah. But I would disagree with that. But no, we have no objection.
Very good. Mr. Mosley, do you object to my remarks? Okay, then we will continue. I see some spectators and I see some folks up on the Zoom device. Is there anyone, we have the Myers, Mr. Charles and Elizabeth Myers here as a party, and we have the town of Boone, Blowing Rock here as a party. Is there anyone else that feels like they're a party and they want to enter into this case?
What do you mean by a party?
You would participate and cross-examine witnesses. You'd be a full participant. To be a party, though, you have to demonstrate that you would suffer special damages if this case went a certain way. And those damages would have to be something unique to you, far beyond what the public, the general public suffers. Special damages is the term.
Yeah, this is right next door to me, and this is negatively impacting my family's life from a quality standpoint. When you've got a never-ending stream of tenants coming in.
Let me get you to be sworn in, if you don't mind, and so that we can hear you. Can you come up here in a nice open spot? Bring your chair with you. Do you want to sit in your chair or stand there? I don't want you to be uncomfortable.
I'll do whatever y'all want.
Well, come on up here.
Can I bring my chair?
You can bring it. That's what I was saying. Yeah. Tell us your name.
Richard Ransom.
Ransom.
Yes.
Okay. And your address, sir?
174 Norwood Circle.
Ms. Huebner, swear him in, please.
I don't have a Bible with me, but,
I've got one on my phone.
you want,
You don't have to have it. You don't have to have a
we're
Bible.
not in our regular.
You can ask him to affirm.
We do affirm that the evidence you shall get to this board shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Okay. Mr. Ransom, tell us what special damages you feel you would suffer if the Myers are allowed to do short-term rentals. That was the side you were on, right?
Yes.
Okay, go ahead and tell us.
We purchased this house back in January and have invested significant funds in it
Okay.
in aims of being part of the community. And it became apparent after, a few months that it was a never-ending stream of tenants or people, I believe Mr. Myers told my wife that they swap their houses in some sort of rental pool with other people. But at any rate, I've got a 13-year-old child, a wife. This is our vacation home, and we invested in this community feeling like it would be a community, not, and somebody running a hotel next to us, which is what's really going on.
Okay.
Every,
Tell us how you would be hurt, that
I know,
damage.
I'm getting at it.
Okay.
I just want everybody to know, and every weekend or every week, there's a different group that comes in. When people rent a house, they want a party. And so they go out on the deck where the view's nice get liquored up, turn on the music, dance around. And that's just not what I would want to be next to. And I'm sure y'all wouldn't want to be next to that where y'all live. And it's our understanding that that's not the way it's supposed to be here. I mean, this is a residential neighborhood. And if you've got people doing that next to you, it certainly negatively impacts the quality of life and property value. And one of the things that's nice about Blowing Rock is this moratorium on short-term rentals, which is similar to Sullivan's Island down in Charleston, which is what makes that place special. Because when you don't have rentals, people are encouraged to be a community with their neighbors. And this is a very neighbor-focused little nook we're in near the country club. And
okay.
To me, it's not rental property. It's family type property.
Okay. So your primary worry would be noise, I take it.
I think we got the coronavirus thing coming on all winter long. We were up here, there's different people coming up that aren't, who knows what they're doing. I can tell you they're not quarantining. They came up every week, different people, and they didn't sit in the house. They went all around the place.
Okay.
So there's that, there's noise, just, nobody, you want to know who, when you're paying, $1 million, $2 million for a house, you want to know who's next to you. And you're not looking to have just a bunch of riffraff coming in and out every week.
Okay. You said you're at 174. Did you say you're literally next?
I'm directly next door. My back deck is right next to theirs. And so I'm the one that hears all this and sees all this.
All right.
And I got nothing against y'all. I just simply don't want to live next to it. I'm investing significant sums in the house.
We got it, Mr. Ransom.
I want to be a good neighbor. And, y'all wouldn't want this going on next to wherever you spend your time.
All right, thank you. Now, before the board votes as to whether or not you would suffer special damages and you're entitled to be a party, Mr. Miller, and then Mr. Mosley may want to ask you some questions. Mr. Miller.
I do. So, do we have an extra copy of the board packet to hand the witness?
Yes. Here's one.
Can I approach the witness?
Absolutely.
Give me 1 second.
It's Mr. Ransom, Grandson.
Yes.
So you just bought back in January,
Yes, sir.
and how long did you have it under contract?
Have it under contract?
Yeah, to purchase it.
I don't recall. And whatever the standard typically is, a month or something.
Okay. And did you talk to the realtor about short-term rentals or anything like that in the area?
I don't recall.
Did you do any due diligence in regards to short-term rentals that you can articulate?
We were aware that there was, some sort of rule against short-term rentals.
So you were aware that there's some rule, but you didn't know what the rule was, right?
No, that it was against rentals shorter than 28 days was my understanding.
Okay. And where does that apply?
In the town of Blowing Rock.
So that's your belief.
That's my understanding.
Okay. Now, so you don't live here, right? This is a second home.
I'm just going to be splitting my time.
Okay. So have you been splitting your time since January?
Yes.
Okay.
Actually, we spent most of the winter up here
So where's your other home?
in Charlotte.
All right. And so you are, remember, if you will turn to exhibit C3 in that.
Yes.
All right. So that is number 9 there. Is that your home?
Yes.
All right. And number 1 would be the Myers home.
Yes.
And y'all share a driveway?
I don't believe so.
There's a shared agreement.
Yeah.
And so that you're not the only neighbor surrounding the Myers homeowner.
Am I the only neighbor? No.
There's house that's on this map marked number 2, and there's a house marked number 6 that are direct neighbors, correct?
They're neighbors, yes.
They're adjacent neighbors, as in they touch the property lines, right? Of
Yes.
house number 1. Okay. And then to get to this property, the Myers property or your property, you've got to drive by number 3 here and some other houses to get here, correct?
Correct.
All right. And so anybody visiting or staying in the Myers home would have to drive by their houses, correct?
Would have to,
Drive by 2 and 3.
yes.
And if they're going to the Myers home, they don't actually drive by your house, do they?
If they go around that curve, is that what you're saying?
If a tenant is staying at the Myers home,
Oh, I see.
they don't go past your house.
No, they do not.
Your damages or whatever you would suffer from this don't differ any more than number 6 or number 2, do they?
I would say mine are higher simply because of the vicinity of my property is very close to the Myers versus number 2 is, there's like an extra lot almost in between, and number 6 is across the street and not privy to what goes on in the backyard over there on the Myers side.
All right, so what exactly is the damage? Like, detail the damage to you that number 2 and number 6 are not suffering.
If you look at the picture there, my back deck where I spend a lot of time is adjacent to the Myers back deck there, and that's where the tenants seem to spend a lot of time. And so it's a noise issue.
And if the Myers were using that and the Myers were out on the back deck making noise,
Mhm.
you would hear that as well, correct?
Yes.
All right. And do you hear the noise coming off 221 below you?
I hear, yeah, traffic.
I'm sorry, I didn't hear.
I said, yes, I hear traffic,
Okay.
which is different than people partying and drinking in your next door neighbor's yard.
And number 2 would hear maybe less, but would still hear the same noises, correct?
I don't know if they could even hear it from there. But maybe, I don't know. I've never seen those folks, so I don't know.
Okay. So you only know what you know being on number 9.
That's correct.
All right. Does number 8 have a house on it, or is that a vacant lot?
That's my neighbor Tony behind you's property. It's a vacant lot.
Number 7, I assume that's a vacant lot.
It's all part of my neighbor Tony's property. And Lynn, his wife next to him.
Okay, and so is their house shown on here?
6.
Okay. Those would be my questions.
Thank you. Mr. Mosley?
What's the approximate distance between your house and the Myers house?
From like
Distance.
the edge of our house to their house. 20 feet maybe?
20 feet?
Something like that, 25.
My own question.
Really asking you, aren't side setbacks 12?
I think they're more than that.
You think it's more than that? Okay.
What side setback are?
It is 12. So I mean, it should be at least 24 is my point. If each house is within their setback.
Anything further from the town? Okay. All right, Mr. Ranson, the last letter is an N, as in
Yes.
November.
Yes, sir.
Okay. Go ahead, if you would, take your seat out here. Members of the board, we're going to vote now as to whether Mr. Richard Ransom would suffer special damages beyond what the general public in the town of Blowing Rock would suffer, such that he would be allowed to be a party and fully participate in this hearing.
Mr. Chairman, I
Yes.
would like to be heard before the board, I mean, the board could deliberate, but before the board votes, I would like to be heard.
Go ahead. Now would be the time.
Yes, sir. So, the appellant, I don't know what our official title is.
You're the appellant.
The appellant, in this case, would object. The proposed intervener has failed to show any special damages that he would suffer that the neighbors wouldn't suffer. He says that he might suffer some noise, but that noise could be from the Myers or could be from tenants. That same noise is going to be heard at least by one neighbor. Yes, the entire town of Blowing Rock will not suffer the same damages as this particular individual, but the neighborhood, and the reason you don't send a notice to the entire town, you instead send it to 150 feet or whatever within the area, is whether those people might be affected any differently. He is not affected, and that family is not affected any more than any of the other surrounding neighbors there. He did not articulate any special damages. And for that reason, it's only, as Mr. Chairman stated, under 168-393 subsection 2, only if they suffer special damages, which is greater than normal damage.
Very well argued, Mr. Miller. Hold on one second and let me
And I object. to-
consult my book.
What would y'all define as a special damage?
I'll read it to you. And this is pursuant to the authorities at the UNC Institute of Government. Mr. David Owens primarily wrote this book. This is somebody's opinion, Mr. Ransom. There's no simple test. The central question is this: has the individual who alleges standing shown that his or her damages are distinct from those damages to the public at large? Here are some critical factors to consider. Proximity. How close are you? Property value impact, and the secondary impacts of things such as traffic, parking, security, litter, and noise.
We have all those and.
I'm sorry. Now's not the time. You made your presentation. You did a good job. Mr. Moser, do you have anything further?
Only that all of those property owners who were served with notice of this would arguably have special damages. So he's making a distinction between Mr. Ranson and the other property owners who received notice who haven't asked to intervene.
Correct.
If his house is within 50 feet from the adjoining property, then clearly he's different from the public at large. He could suffer special damages. I think it's pretty clear.
Okay. All right. Let's just go right to it. Those members of the board that think Mr. Richard Ransom would suffer.
We'd like to, we're number 6 on that list. We're house number 6.
All right, let's take care of Mr. Ransom and then we'll get to you.
Okay.
Those members of the board that think Mr. Ransom suffers special damages and should be allowed to participate as a party, say aye. Aye. It is unanimous. Now, Mr. Ransom, you're now a party. That means you get to cross-examine witnesses. And I'll let you know when that time comes. All right, so you're a party. Does anyone else feel like they have standing to be a party to this case?
Can we do 2 of us as a couple, or do we do it individually?
Are you a married couple?
Yeah.
Could you have one of them, just for the sake of time, one of you be the spokesman for the pair? You want to bring your chair or you want to stand? What is your name, sir, and what is your address?
William Barber, 172
Well,
Norwood
that's,
Circle.
slow down. William,
Barber,
B-A-R-B-E-R,
OUR.
B-A-R-B-O-R.
OUR,
O-U-R, I'm sorry. What is your address, sir?
172 Norwood Circle.
Would that make you next door to the Myers or two doors
I'm not
down?
adjacent, I'm in front of, the street that services my neighbor Skip's house goes directly down the side of my property. And their house is beside my house essentially, but they face me.
You're number 6, right?
Yes.
Okay, all right. Ms. Hugo, would you swear in Mr. Barber?
You affirm that the evidence you shall give to this body, you and her, shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Mr. Barber, if you feel like you would suffer special damages if this case went one way or the other, tell us what those special damages are. Go ahead.
Well, we have lived at the house now for about almost 2 years. And when I bought the house, I did check to see if there was rentals in the area, and there was no history of anything. And my realtor said there was no history. So it mattered to me, and I know it'll matter to the next person who comes to my house to buy it if I decide to sell, which would decrease its value. But besides that, now we have the COVID virus, which I think is a very real thing. And these are huge, 5, 6, 7, sometimes as many as 8 or 9 people that come to the house and stay there that are coming from states outside of North Carolina. And because I can tell by their license tags. And they are walking and roaming around and exposing us to possible contamination, which is consideration. And it's an unfair because no one else in our neighborhood has to deal with this. It's my house, my neighbor Skip's house, and there's no one that lives permanently in the house that's beside on the other side of the house. But so we're 2 people that are affected directly by this, and none of the rest of the neighborhood is. There's no other rentals, so there's no one else. So I think that it's not reasonable to expect us to take that for someone to make profit in a situation where it's already stated that short-term rentals is not acceptable.
All right, other than your fear that you and your family may be exposed, may have more exposure to COVID, do you have any other?
Loss of property value.
Well,
And
you're going to have to bring an expert in here to talk about that, but were there any other harm, anything that
uncontrolled egress and accessibility to my property by people who don't know that are transient. I think that's a risk, and that's a risk that I shouldn't have. And then there's all the noise. I can hear them just as well as Skip can. And Mr. Miller seemed to think that he was the only one because of 24-foot setback. I'm easily 50, 60 feet from their deck, and I can hear them when they're partying. And it's deleterious to my enjoyment of my afternoon and of my property. And I don't think someone should have the right or ability to cause me not to be able to enjoy my property any more than I would theirs. And if I did something to cause them to not enjoy their property, they would certainly come and speak to me, I would think, or at least bring some sort of suit. So I think there is damage there that does not exist in other parts of the same section.
Okay. Mr. Miller?
Yes, sir. Mr. Barber,
Yes,
you said you bought your house 2 years ago,
yes.
and you said you checked, when exactly did you buy your home?
July of 2019. No, yeah, 2019.
So 1 year ago.
Yeah, a year and 3 or 4 months.
Okay, so you're relatively new to the neighborhood as well.
Yes.
Are you aware that this house has been short-term rental since the 1940s?
No, I wasn't, and if that's the case, I think proof needs to be shown that that exists.
But what investigation? You said you did an investigation.
I asked my realtor.
Okay, so you asked the who's
She
your?
said,
Sir, hold on. Let me ask the question,
okay,
and then I'll let you answer as long as you want. Who was your realtor?
Advanced Realty,
At a booth?
yes.
Okay. And so did you talk to Mr. Rothrock?
No.
Did you, ask to go see any permits in his office?
No, I trusted that what I was hearing was correct. That if there had been rentals there, it's a very close-knit community, and I spoke with several people that live there also, and they weren't aware of rentals being in that house. So I had no real reason to pursue it further. And then they just started showing up.
They've been showing up since you owned it, since 2009.
There's not been one there until the last 3 or 4 months. Before that, there was nobody there.
Right.
Not rentals,
Well, you don't know if they're rentals or not, do you?
just these people is the only ones I've seen.
Do you know them by
I
their
don't know
name, or
them.
you just know them as these people?
These people, I don't know them by name, I just recognize their car when they're coming in and out.
So you don't really share, you share a driveway access is all you share, correct? I mean, I'm just looking at the overhead picture. I understand you don't have.
There's an access road from Mr. Ransom's property that comes down my property line.
May I approach the witness just to show him the?
Yes, sir.
I don't know how many of these copies we have. I'm showing you what's marked C3. Is that the access road you're talking about? This is your house?
Yes.
Okay. So my question is, this is the only common boundary or common use you share with,
Yes.
and we're pointing to where your driveway meets the U of the Myers Road. So you said that your special damages are potential exposure to COVID.
Yes.
Or do you go to the grocery store up here?
No,
Okay.
only my wife, and she wears a mask and special equipment and everything. We stay right at the house,
Okay. So you don't go anywhere.
pretty much no.
Okay. But you're sitting in a room with a mask off right now.
Yeah, and I'm at least 20 feet from you, maybe.
Yes.
I mean,
So-
I follow the guidelines.
Okay. If, and you understand this is at least the county has a university in it, right?
Yeah, I'm aware.
Okay. And there's a transient population in that.
Yeah, but that's 7 miles from me.
And renters don't come on your property and knock on your door or anything.
They walk on my property, they don't knock on my door. I guess if they needed to, they would. The risk exists, whether or not it pans out that way. In one way, that's the risk that we take, but I'd rather not raise the risk by allowing more people to have access to walking across my property. If I'm happen to be out in the yard, they want to come over and say hello, I don't want that. I don't want people coming from out of state to do that. I think that's the risk.
So is there something that you're aware of that would block me from going on this Norwood Circle as a citizen of the United States to drive on Norwood?
Absolutely not. But if you were a citizen of the United States coming onto my property, I would say, stop. Don't come onto my property. But if I've got 7 people I don't know and they just walk over, they might get, it raises the risk of infection to have them there. If they're not there, then the risk doesn't exist.
What part of your property have they gone on?
I'm sorry?
What you say that people.
They walk out into the road until it touches my property. They walk out. They walk their dog.
So are they walking on the road or your property?
Well, my property, the dog doesn't poop in the road. He poops on the grass and they walk with him.
We'll get to that. All All right, you're saying you hear the same noise that Mr. Ransom.
I can't say it's the same noise. I hear noise. I hear partying. I hear loud music. I assume it's coming from that house, so it's gotta be them.
All right, those would be my questions.
Thank you. Mr. Mosley?
No questions.
Mr. Ransom, you're a party. Do you have any questions of Mr. Barber?
No.
And I was negligent with my fellow board members back with Mr. Ransom. I should have asked you if you have any questions for Mr. Ransom, and I ask you now if anyone has any questions for Mr. Barber. None? Mr. Miller, we're getting ready to vote. Do you have anything further?
Based off his testimony, he has, I mean, the only credible thing that I found was in regards to the noise. In regards to what the special damages might be, those don't differ, and in fact, would only tend to be less if they're on the back deck partying. The house would block it, plus a considerably longer distance than Mr. Ransom. So you've got one intervener. I don't think that he has shown any greater special damages, and I don't think he's shown any special damages. So for all the reasons that I objected to Mr. Ransom, I object further to Mr. Mosley.
Anything further, Mr. Mosley?
No.
I'd like to take up a little discussion. Mr. Barber, would you go ahead and retake your seat? Take your chair back. Mr. Barber says there's noise from the deck. Anybody using the deck is going to make some sort of noise. A conversation makes some sort of noise, and it wasn't. I didn't hear from him about an excessive amount of noise, and we need to decide on Mr. Barber from Mr. Barber's testimony and not from Mr. Ransom's. The risk of COVID. Well, anyway, all those in favor of
I'd like to.
oh, sure, I'm sorry.
He used the term loud music. I think that changes.
I didn't hear that.
Yeah, he said he used the term loud music. And I think that changes the maybe the assessment of whether he is a party or has damages. So different from using the term music, they use the term loud music.
Okay.
I have a question as well, EB.
Sure.
He mentioned, does he really need to bring an expert in to talk about property value?
Yeah.
He does?
Yeah.
So we can't use just common sense?
No, unfortunately, we can't.
Okay.
Do you have anything else you want to add?
No.
Steve, anything?
Well, we have ordinances against loud things all the time up here. And so those kinds of words are nice, but I'm wondering right off the bat, well, what's loud to you and me? And, that's sort of relative, isn't it? But apparently to these people, it's loud enough to make them so that they don't like it, and and it bothers them. And
I was a bit condescending
in
about
R15, we're not supposed to have short-term rental, and we certainly aren't. I don't care whether it's if it's a real loud family, even if it's bothering the neighbors, they can object to it, and they can have a police officer or somebody come and talk to them, or they can call and ask them to quiet down. If they don't, then they can take the next step after that. So that's sort of what I'm hearing from these two people.
I was going to say, I'm sorry, I didn't mean to cut you.
No,
I was a
I'm
little,
hearing that they don't like it.
I was a little condescending about the risk of COVID, but I suppose if you had visitors from other parts of the country, and a high turnover of folks from other part of the country, I guess you would have a higher risk of COVID. All right, anything further
Well,
from,
if you want to talk about the COVID thing, you know, what was it when we first boomed past the ordinance that there was a quarantine
Yes.
originally? It's no longer in existence. So obviously there is a risk. I mean, not being a physician, there is a risk. We don't know the exposure of people coming into our community.
but you are a physician.
Yeah. But we don't know the exposure of people coming into our community. So you take a risk. And you would hope that, you know, I know what my exposure is and what my risk to you is, but I don't know may not know what someone coming in from another area, what their risk is to me. And they may not know they're at risk either. So anyhow, that's just my
Okay.
statement about COVID risk.
All right.
There was a quarantine initially for our county.
All right, all those in favor of granting Mr. William Barber standing as a party, say aye. Aye. Any nays? All right, Mr. Barber, you're a party. You'll be able to ask questions of witnesses, and I'll let you know when that time comes. Is there anyone else here in the room that thinks they have standing to be a party? Okay. I see some folks on the Zoom. Anybody out there in Zoom land that thinks they have standing to be a party to this case? Okay. Anybody that's going to be a witness for either side in this case, let's swear everybody in at one time now. If everybody that's going to testify could pay attention to our clerk, Ms. Huebner. I turn it over to you, Ms. Huebner.
I think I saw my wife waving.
Yeah.
She was trying to get your attention.
She's muted according. Ms. Paige Ranson, can you hear me? You're muted. Are you doing it or are we doing it?
I think, Kevin, are you doing it still? Or
Now we can,
can you hear me now?
yes.
Okay, great.
Uh,
Can you hear me?
Go ahead. What did you have to say?
I just wanted to make one comment that I think we're all overlooking. And I look at this, I guess, totally different too from a mother's standpoint.
Yeah, wait a minute, Ms. Ransom. Wait a minute. You don't get to just start
Okay.
rambling. I asked if anyone else felt like they had standing to be a party. Did you want to get our attention for that reason?
No, I was just trying to add to what my husband had said.
Okay, you don't get to do that. Now, are you going to be a witness?
Yes, sir.
Okay, we're going to swear in all the witnesses. So pay attention. The clerk's going to swear everyone in at one time.
What we do is unmute everybody.
Yeah, I think you have to.
This might be. Dan, go ahead and unmute.
Yeah. There you go. Thank you.
Is Sam gonna be?
Sam, you too, if you're going to unmute. There you go. Okay.
Okay, do you affirm that what you should give to the information you shall give to this board is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes, I do.
Okay.
I do.
All the witnesses sworn?
That's what they're repealing.
Okay. Mr. Rank, did you take the oath? Did you say you would? Okay. Mr. Ransom, you're going to be a witness, I assume. All right, okay. Mr. Barber, you took, okay, all right. So we've sworn all the witnesses. And if you folks will go ahead and mute, because we got a lot of echo.
Okay. Mute again.
So we're going to start with the town. The planning director ordinarily gives the town's case. And I assume, Mr. Rothrock, that's going to be you. So let's get started. Yes.
Before we do, I noticed there was a conversation between board members. I couldn't hear it, so I just asked as to what it was.
The question was about noise. And the question is, Mr. Steele was asking me, the issue is noise and it's against the law. And I said, yes, it is against the law at a certain level. I mean, there are noise ordinances we have here, as was alluded to, I mentioned. And so I just mentioned that means if there's loud noise, you have, that may give you standing to be able to be a party in this discussion.
Thanks, sir.
All right, let's start with the town's allegations, the town's case.
Okay.
6:30, everybody's planning purposes. We're going to break this hearing. It's still going on at 8:30. Letting everybody know, it's still going at 8:30.
I'm ready to rock and roll.
Go ahead.
All right. This is appeal case 2002-02. The applicant is Mr. Charles Myers and Ms. Elizabeth Myers. Location is 178 Norwood Circle, and the zoning district is R15, single family.
Keep your voice up. Some of us are getting on it.
Okay,
Keep your voice up.
I can keep it up. Just make sure yours is down. I'll keep this one up, your volume.
Mute it.
All right, we're good. Mr. and Miss Charles and Elizabeth Myers have appealed a final notice of violation issued to them on August 3rd, 2020 regarding short-term rental of their property at 178 Norwood Circle. Short-term rental is a period of rental less than 28 days. The Myers property at 178 Norwood Circle is zoned R15, single family, where short-term rental of property is not permitted. Property is further identified by Watauga PIN 2817-136488-000. The town received a complaint of short-term rental activity at 178 Norwood Circle. In response, and understanding that short-term rentals have not been known to have been grandfathered at 178 Norwood Circle, staff sent a notice of violation to the property owner detailing that short-term rentals were not allowed in the R15 zoning district. A notice of violation was sent by certified mail on August 3rd, 2020, and received and signed for on August 6, 2020. An application for appeal was received on September 4th, 2020, which is within the required 30-day appeal deadline. Public notice for this appeal was mailed on October 9th and then corrected on the 12th to the property owner and adjacent property owners within 150 feet. The property was posted on October 9th, 2020. Public notice appeared in the Blowing Rocket on October 15th and the 22nd today. The difference in the corrected public notice was that we were moving it to here because of the early voting at Town Hall. Attached in your packet, and everyone I believe has received it and seen it, is a copy of the notice of violation, Exhibit A, copy of the appeal, Exhibit B, which is B1, the application form that we have, and then their attachment to that as B2 is copy of the notice of violation they received, the Myers received. Exhibit C1 is the public notice that went out. Exhibit C2 is the list of those property owners that received the notice or where it was mailed. And then Exhibit C3, which we used earlier tonight, was the map that showed those properties that had received notice. We're familiar with the property, and Exhibit D shows the property on an aerial photo with the red box around it. And then the zoning district is shown on Exhibit E, that is R15, the yellow that is shown there, and again, the red box around that. That is all for the staff report. I have some other documents that we can introduce on the town's behalf later, if that would be appropriate.
Other than the staff report,
Other than the staff report.
go ahead and get in everything.
All right. Okay.
Burden shifts to me. I don't think it would be proper for them to introduce evidence. And now, if they want to keep the burden, which the burden should stay with them, but if they want to keep the burden, then I think they should be allowed to present evidence.
Ordinarily, you get them to put up everything they have, get the town done, and then return it over to the appellant. The burden switches to you, all that shows the violation, current violation of town ordinance. Saying, before they go any further than that.
Well, I'll make a general statement that I feel that the burden should be unconstitutional, but that's a personal feeling that is not going to be decided by this board. All he has to do is and I know Kevin, I respect that very much, but all he has to do is notice a violation, and the burden automatically shifts to the appellant. They don't have to do any investigation, but regardless of that fact, for the purposes of this hearing, they have presented their evidence as to what the violation is. The burden would then be on us to prove that it is not a violation. If they're introducing additional evidence, we weren't given any notice of this additional evidence, which would be our right as an appellant. You know,
That would be like discovery. You don't have any right to do it. You got a copy of the stand, they have just.
Excuse me, I don't disagree with his position. I have no idea what else Kevin intends to introduce, but they do have the burden, and I have no objection to them starting their case now, and then we can come back to him and he can introduce whatever, and he's probably going to testify as well.
Okay.
That's fine with me. It's no more than sections of the code that you already brought to us at the beginning. It's just the ordinance that was adopted and sections of the code pertinent that I did not include in the staff report, but do whatever.
If it's just the code, then I'm not gonna have an objection. It's just the code.
That's all it is.
But if it's just the code, I have no objection to the code, because that's not really evidence.
No, it's just section of the code, definition, table of permitted uses.
If he feels it's relevant, let's figure it out.
Sure, that I have no objection to that.
Show Mr. Miller what you want him to do. Make a call to the record.
Okay.
And shows Mr. Ransom and Mr. Ball.
$18. 19. That's the definition. Table permissive uses in that section of the article. And then the section of the code was that put there in section. Use my copies of these. But I can make.
You need to see these, Mr. Moses. Mr. Rothrock, if you would show Mr. Ransom, Mr. Ball. Start examinations tomorrow.
So I don't understand on the ordinance, amendment to regulate short-term rentals. That was passed June 12, 2018, but it wasn't signed until August 13, 2019.
That's right.
Why?
It had to be corrected. There were some things that were not included in the final draft. And then when we finally got the right copy, it was signed in August of 19.
So the town council passed it, and then a year and some months later is when it was actually signed and adopted.
Yes.
So when did it become effect? On August 13th?
2019, yes.
2019. Okay.
There were some parts of it that were found that were not consistent with what we thought that they were. But we found out that there were some things that were not included in the ordinance that had to be corrected. So then the final version was signed then.
So in non-conforming uses that were in existence prior to August 13th, 2019, more specifically short-term rentals in areas that are now banned, if they were in operation then, there is a provision in here to allow this to continue to operate so long as they comply with the grandfather status and the other ordinances, right?
The ordinance that was signed in 2019 was an updated section of the code.
Sure.
We already regulated short-term rentals as far back as 1984.
Okay.
There was another ordinance in 2000 that further that added some clarification to our ordinance and also adopted short-term rental overlay district. So that was 2000. We did some more work since then in 18 when we adopted the short-term rental section of the code that dealt with getting a permit where it is authorized. And then that was the one that was finalized in 19.
So going back, you said 84 was the first time it was regulated.
That's right.
So in 1984, if there was a short-term rental operation, in what would now be a area that's not allowed, it would be grandfathered in so long as it continued.
That's right.
And the town would, if the town knew about it, would allow that use to continue.
That's right.
That's one question.
Mr. Ransom, if you have any questions of Mr. Walker? Mr. Walker, do you have any questions of the planning board? Board members, do you have any questions? Okay.
In 1984, Kevin, was anything official? Was it just automatic blanket grandfathering if you were doing short-term rentals? Or was there some kind of, you go to the town and say, this is what I've been doing, and I'd like to continue doing it, and the town said, okay.
I don't know. I mean,
Okay. Does anybody know?
I wasn't here. I don't know how it was done then. I just know what the code said then, but that I don't know how it was treated.
I have some questions. Do you have a copy of the official zoning map?
I don't have it with me, but I have a small version, I believe here. It's a little bit older too.
Includes the property in question on the word.
Yes,
And you said it's zone R15.
yes,
How long has it been R15?
since at least 1984.
And the zoning map that you're holding, you said it's small in scale, it doesn't include the property in question.
Yes,
On the map. It's in the R15 district,
yes,
and can you make that record to the copy of the record later?
absolutely.
Tell me about the house. Do you know when it was built?
I don't have any idea.
Have you given proper notices to the public and the neighbors this year?
Yes, sir.
Let's look at your, alleged violation to fires. So they have received complaints. How many complaints did you receive?
I received one,
And who was that one?
Mr. Ranson.
When was the property supposedly managed? What time is the basis for your notice of violation?
July 2020. I don't know exact date, but like the first contact I had, I believe, was July of 2020
First contact you had?
that I had from Mr. Ranson. Yes, sir.
Did you have other contact?
I mean, since I sent this violation, yes, I've had some since then. But my first initial, in which started the process, was through Mr. Ranson in July.
And did you get a knock on the door at 178 Norwood Circle?
No,
Why not?
I didn't go visit. My first,
I'm sorry, what?
I just sent the letter.
Did you contact the Myers before you sent the letter?
No, sir.
Did you check the internet to see if there was any advertising for rentals for 178 Norwood Circle?
Yes.
Were there?
None.
Nothing on the internet.
Nothing.
Any other questions from the board?
Back to my 1984 question. So how do we know who's grandfathered and who's not?
It's a very short list of those. I know there's one on the corner of Morningside and 221. And there are some that are in the ETJ that were doing short-term rental prior to the town taking that into extraterritorial jurisdiction in 2005. And we know which ones those are. We know the owners that own those. Yes. There's a few in Sunrise Cove, if you're familiar with where that is. Yes.
Kevin, how long can somebody be in non-conformity from a grandfather situation? If something is passed in 2010, how long would that non-conformity thing last? As long as the original owner had it, or is it passed on from one to the?
It can be passed on through ownership. Yes, sir. As long as not more than 180 days pass from one to the
Short-term
other.
rental, what you're telling me then is that as long as 180 days, there hadn't been any rental in that 180-day period,
Right.
then it would end.
It would.
Then
It
the
would.
grandfather would end.
It would, unless they were getting a permit to do renovations and they let us know, hey, we've been doing short-term rental, and if we agree, yeah, you've been grandfathered in, and they do that work, when they're finished, they can go back to resume that grandfathered status of that non-conforming use. That would be the exception.
Is that fairly common knowledge? When people buy houses? You think?
What is,
Rules like that, rules like grandfather.
I don't know. You know, realtors ask me, I get calls every week about the status of certain homes, whether short-term rental is allowed. I get those calls every week. I got 5 calls this week about properties down in Laurel Park about short-term rentals, if they're allowed.
You have a list of properties in our town that are grandfathered for short-term rental?
I may have a list on the computer, but I can't say for certain.
Brings up a question I have. Ask this. In the new ordinance, it gives a system for regulating lawful short-term rentals. You get some kind of a permit, you have to put up some protections and so. Who administers that? Do you do that, Mr. Rockwell?
Yes. Prior to COVID, when we were a full-time working in the office, and Tammy would receive those applications. We still get some occasionally, and we process them in our office, and then a permit is issued.
Did you get an application for this one?
No.
Mr. Ransom, anything else you want to ask Mr. Ross? I have to ask you this question.
I understand.
I'm not giving you a hint.
I'm thinking, give me 1 second. I will add, when I spoke with Mr. Rothrock.
Just a question. You're gonna get testified later,
Right.
so you'll get another bite at the apple. Right now, you have a question.
Mr. Rothrock, were you surprised when you weren't able to find advertisements on the internet, yet I was telling you that this was continuing? And did you have a question of how that might go?
Yes.
Care to elaborate?
We use a system in cooperation with the TDA. It's called STR Helper. And it combs the internet looking for short-term rentals through HomeAway or Airbnb or some of the other platforms where short-term rentals are being advertised or used. We didn't find this location. So it's somewhat surprising because that's how a lot of people find them. So I didn't, and I had not received any complaints prior on this property.
That's all.
Mr. Walker, any questions?
Yes, it is. What proof would be sufficient to say that this property has been in continuous operation for rentals, short-term rentals since 1984?
Well, I'm gonna object this, asking you to respect that, Mr. Walker, that's not fair.
Oh, and I was just asking what he would accept.
That's what we're here on. Oh, there's the papers that you were shown. Did you get the papers back? We gotta get our papers back. Remember to share them with you?
Yeah.
Could you hand them to this man in the white shirt?
I didn't miss it.
Thank you.
Mr. Miller, anything further from you?
Yes, sir.
Go
Mr. Rothbard, in regards to non-conforming situations, that's actually part of your ordinance, isn't it?
Yes.
Okay. And that's the same ordinance that deals with all your land use regulations.
Yes.
So anybody would have, anybody who looked into ordinances could find the grandfather in the 180 days of non-continuous use to see how grandfather use would go away.
Yes, sir.
In regards to, did you look at the county tax records in regards to this property?
I pull up the GIS that we have, and it utilizes the county tax records as its base information. That's how I found out who owned it, and the mailing address.
So utilizing that same county website and the county information that you have, did you notice that the house was built according to the county in 1941?
No,
Do
I
you
just
have any-
didn't look for that. I'm not refuting it. I just didn't see it.
And that was gonna be my next question. Do you have any reason to doubt that the county's information is incorrect?
No.
And you said you've not had any other complaints on this property for short-term rental?
Not prior to
Not
Mr.
prior.
Ranson, after, and when the notice was posted, I started getting calls, and the calls then were, they're still renting. And my response, well, they've made an appeal, and that stops any enforcement action until the hearing. So they understood that.
So prior to noticing the neighbors, you'd never heard anything, right?
No, never.
Are you aware, I understand that you're not the police department, and do you enforce the noise ordinance?
I do not.
Are you aware of any noise ordinance violations for this property?
I'm not.
If somebody does not advertise their property on the internet, would your software catch it as a short-term rental?
I'm going to say no, since it's combing the internet to find it. So I would say no.
And when you did an ordinance in regards to the changing of short-term rentals recently, I know I'm assuming you weren't here in 1984 dealing with it then.
No.
But when they were changing it recently, I understand, just because I live here, that there was hearings on it and there was stuff in the local paper about it. But were the property owners at large notified by any other means other than local media and your normal meetings?
For the ordinance in 18 and 19, no.
So you don't do some sort of special mailing to all property owners saying, we're amending ordinances?
We did not with that one. There have been notices in the past about the current ordinance prior to 18 that would go into water billing. So everyone would receive that. Even before I was here, I know the manager, when I came on board, Don Holycross, there's letters from him that were sent out town-wide to those that had water bill accounts, just informing them. There are letters that I've sent to realtors, all the realtors in the area, about the standards that we have dealing with short-term rentals and where those are allowed.
Okay. So you're saying, like with the water bill, sometimes some sort of notice will be sent out?
Yes. We have a newsletter, and then any updates, and I don't recall exactly if we did it for the 18 amendment, but in the newsletter, what's that called? Around the Rock, we would have a little blurb in there about short-term rentals and any activity and code changes that we would have. Yes, sir.
Mr. Mosley, do you have any questions?
Yeah, I have a few. So what's the, I know it's part of these documents here, but what is the current definition of short-term rentals? I'll look at that.
Yeah. Okay. Short-term rental of a dwelling unit, the rental, lease, or use of an attached or detached residential dwelling unit for a duration that is less than 28 consecutive days.
And when was that definition, when did that definition first become part of the
In 2000.
And in 2000, how did that definition come into play? Was it by ordinance?
Yes.
And what was the purpose of that ordinance?
Just one second. The purpose of the ordinance was to establish an overlay district, short-term rental overlay district that would be applied over the multifamily residential zoning districts. And at that time, some basic terms were added to the ordinance: overlay district in general, and then short-term rental of a dwelling unit. The same definition that we currently have was added then in April of 2000. And then all the language dealing with the short-term rental overlay district.
So are you actually looking at the ordinance from 2000?
Yes,
Is that part of what you were introducing?
I have not. No.
Do you have any objection to that becoming part of the record?
I would like a copy of it, since I had no way of getting the 2000 ones. And I would just, I know Mr. Mosley has institutional knowledge. I'm just wondering, how long you worked for the town as well?
19 years.
So around 2000?
2001.
2001.
Yeah, after all this.
Okay. I just wondered that.
Would you like to see it?
I would.
I
love
don't-
to see
yeah.
it.
This includes the minutes and some other things besides that, but it's everything from that day. If we were in town hall, I'd make you a copy.
Few minutes, Mr. Moore, I wouldn't mind doing the rest of it.
Yes, sir, that's okay.
Okay. Should we try?
He's getting answers. What did he say?
So Dan Phillips he's on there. Dan, place to be. Dan put his testimony
Who's witness is it gonna be a council?
He's a town's witness. I just don't, we can't do it.
Well, we're doing all the town now.
Well, his point is well taken, and that is he has to learn.
Any other witnesses besides Mr. Rothrock that the town wants to put up?
There are, Mr. Phillips, Ann Phillips wants to testify, and Sam Hess. And of course, these folks who are present have at least one of them, Lynn Barber, will probably want to testify. She's not specifically an intervener. And so my discussion with Mr. Miller was that he does have the burden. He wants to proceed with his evidence. And you know, I don't want to speak for him, so he can speak about what he believes his rights are as the appealing party.
Since we have the burden, it would be our prerogative at this point to put on evidence. I didn't object to Mr. Rothrock giving us statutes and ordinances of what he was relying on, even historical ones. But I would object to the town, unless the town wants to reabsorb the burden. If they want to reabsorb the burden, then I would let them go first.
Okay, all right, well, they have,
I don't know if they can
they
do
put
that.
up their evidence to establish a violation. So we'll let you proceed now with the Myers case, but the town will have the right to bring back some witnesses after Myers. So with that understanding, proceed with the Myers case.
First, before I begin, I would move at this point to dismiss the town's case. And where I heard what Mr. Chair said about they have established that a violation occurred, but we have not established, based off just their notice, that a violation occurred. What we heard from Mr. Rothrock and town in regards to that was Mr. Ransom made a complaint. Mr. Rothrock searched the software, did not go out to the house, sent the notice of violation, and that's where we are here. So we never actually established whether there were short-term rentals at the house or not.
Let's look at the handout I gave everyone before we started this.
I could add color to that.
So,
I could add color to that.
no, not right now, not right now. Let me see if I have enough copies of this to give the other parties. I prepared this. This is a list of pertinent law, pertinent to any short-term rental case. Let's look at the top. The burden of proof shall lie upon the appellant. That's the Blowing Rock code section. And then another code section deals with the administration of short-term rentals. It says someone applying for zoning permit for short-term rental use in the area not permitted by right. In other words, the zoning district that forbids it must provide historical documentation on conformity and legally obtained. However, the local governmental authority bears the burden of proving the existence of a current town violation. The North Carolina Court of Appeals says that. The town leads off. They have to show the existence of a current town violation. Another Court of Appeals case, ordinarily, once a town meets its burden to establish the existence of a current zoning violation, the burden of proof shifts to the landowner to establish the existence of a legal non-conforming use or other affirmative defense. Now, Mr. Miller, do you feel like, well, let's go with the document that started this entire thing, and that is the violation notice. Final notice of violation dated August 3rd, 2020, addressed to the Myers. I think we all have a copy of that. Signed by Mr. Rothrock. He says, this is to inform you, you may be in violation of Chapter 16 of the Blowing Rock Town Code. This whole notebook is Chapter 16, but that's okay. The short-term rental section is in there.
He says, we have received complaints plural, that your property at 178 Norwood Circle is being used illegally for short-term rental. And he goes ahead and gives a definition, a brief definition of short-term rentals. Speak to this final notice of violation, Mr. Miller. Do you have any problems with it?
Sure. So the first sentence, this letter is informing that you may be in violation. So there is a difference between may and shall. And again, you know, it's not definitive that you are in violation. They point, Mr. Rothbart's letter here points to nothing other than we received a complaint that you may be in violation. Nothing that complaint has been confirmed, or anything that would effectively shift the burden based off the case that you provided here. The local government authority bears the burden of proving the existence of the current violation. Then once that violation has been proved, then it shifts to us. This is, you may be in violation. The very language here states that they haven't met the burden.
Mr. Mosley, I'm going to want to hear from you in a minute, and Mr. Ransom and Mr. Barber. The letter
Now they can. I had to unmute so they can hear. You gotta speak up because I'll.
Okay, I'll try to speak up. The letter, the final notice of violation, is a notice document. Says you may be in violation. I don't think I have a problem with the word may. It says we've received complaints that property is being used illegally for short-term rentals. Doesn't say when. It doesn't say whether it's being used for a short-term rental in 1989 or 2017. It doesn't give a time. I turn to the administrative appeal document, the staff report. It also doesn't allege a time. It doesn't even give a year when this illegal activity is taking place. I see real problems with the notice that marks that decision. Mr. Mosley, do you want to speak to that?
So I'm looking at section 16-5.1 of the land use ordinance, which is the appeals section. It states that an appeal from any final order or decision of the administrator may be taken to the Board of Adjustment by any person agreed. And then it states.
Let me slow you down all the time. Just one second. Where are you?
I'm reading from 16, it's in the land use ordinance, it's on page 5-1, it's 16-5.1.
Okay, the Board of Adjustment shall hear the sign. Is that what you want?
16-5.1 again states, an appeal from any final order or decision of the administrator may be taken to the Board of Adjustment by any person agreed. An appeal is taken by filing with the administrator and the Board of Adjustment a written notice of appeal specifying the grounds therefore. So in this final notice of violation, it states clearly, and it tracks what 16-5.1 states. It states that this is written notice of violation constitutes the final written notice And it gives the property owners their appeal right as required by Article 5 of the land use ordinance. So the final notice of violation is in compliance as this relates to the burden of proof. The purpose and intent of
Let's,
the,
I want to hear you on the burden of proof, but let's finish with the document as a notice document. Number one is the alleged time. Doesn't allege any time, doesn't even allege a year. Tell us your position on that.
I don't believe he had to state anything more specifically than what he stated. He's given them proper notice that he has received complaints that the property is being used illegally for short-term rental. That constitutes notice. It specifically states what the violation is of the land use ordinance. I don't believe that the land use ordinance would require that he set forth specific dates of the violation.
Well, let's just talk due process though. If someone served an arrest warrant, Joe Smith, and said, you've been embezzling money from your employer, and it doesn't allege a date, do you think that would be proper due process? Due process is just a fancy name for fair. I think that would be fair. That gives somebody a time frame.
I don't think the analogy works. I mean, this is a zoning violation and is specific enough to put the property owner on notice of what the alleged violation is. It gives, and it doesn't, it's not the same thing as what you just compared it to.
Well, you're alleging breaking the law. When you break the zoning law, you're breaking the law. People take that seriously. A lot of people take their reputation in the community seriously. If you use a breaking the law, it's a big deal. You need to have something to back it up. Let's digress for a minute. I'm looking at Article 7 in the Rolling Rock Code, and enforcement and review. And at the top, it's got section 16-7.1. And I know I'm putting up some people at a disadvantage. The first part I'm going to read verbatim. It says, whenever the administrator, that's Mr. Rothrock, the planning director, and he's also known as the administrator, receives a written signed complaint alleging a violation of this chapter, he shall investigate the complaint, take whatever action is warranted, and inform the complainant in writing what actions have been or will be taken. Now, I take it there was not a written signed complaint taken from Mr. Ransom.
No.
Let's turn, Mr. Mosley, let's all turn to the administrative appeal, the typed document that lays out the town's case, so to speak. There's your introduction. And it basically mirrors what Mr. Rothrock testified to initially. And once again, it doesn't allege a time frame when the short-term rental took place.
Well, it's ongoing. So let's go, if I may, let's go back to, and I know that Mr. Miller is disadvantaged because he doesn't have the ordinance.
Which one?
The land use ordinance. You have the entirety of the ordinance?
Y'all
Okay,
do give free internet, so I appreciate that.
So let's go back to Article 7. And you mentioned 16-7.1. That's what that references what the administrator is required to do if he receives a written signed complaint. It's not the only basis upon which the administrator may discover violations or cite a property owner for violations. So 16-7.3 states that the administrator finds that any provision of this chapter is being violated, he shall send a written notice to the person responsible for the violation, indicating the nature of the violation and ordering the action necessary to correct it. That's what this is, what he did. The final written notice, which is, it clearly says this is your final written notice. The final written notice and the initial written notice may be the final notice, shall state what action the administrator intends to take if the violation is not corrected, and shall advise the administrator's decision or order may be appealed to the Board of Adjustment as provided in 16-5.1. He tracked that exactly as he was required to do. He wasn't required to say, on August the 10th, you engaged in a short-term rental. He wasn't required to do that. The property owner was on notice. They knew what they already knew what the complaint was, and they already had their position with respect to why they can continue their short-term rentals. They've already indicated that.
No, they haven't put up the case yet.
Well, but we've kind of gotten that forecast from Mr. Miller.
Now briefly respond.
I'm gonna let you speak fully, but let me finish with Mr. Mosley. We'll speak to the issue of due process, fairness. Is this final notice of violation fair? Does it apply to what they've done and when they've done it sufficiently to be fair?
Yes.
All right, Mr. Miller, we're talking about just the paperwork.
Yes, sir.
We're gonna get to whether they've proven that their burden to prove a violation. But what's your position on the final notice of violation and that administrative appeal type sheet?
Yes.
As far as sufficiency.
So I do feel that it is insufficient and it would violate my client's due process rights to know exactly time, manner, place of what they are alleged to have done, when they're alleged to have done it, so that they can come in and properly defend themselves I know you brought up a criminal analogy, but even in the criminal analogy, even when you allege it with probable cause to get the warrant, which time, manner, place matters, the burden stays with the state. Here, it's more onerous because they send this notice out and the burden shifts. So then all of a sudden the burden shifts. Well, if the burden's going to shift, we have to be able to come in here, and this is the trial court, because we are not allowed, if we appeal to Superior Court, it's a non-trial de novo. They're a citizen appellate court. So going to 16-7.1, regarding Mr. Rothrock's representations in his letter, and a little bit of his testimony, in that this came from a complaint from Mr. Ransom. That's where the alleged violation came from. So 16-7.1 is what applies. Mr. Rothrock went online and couldn't find where it was a short-term rental, couldn't find anything online that said it was a short-term rental. So, he did a little bit of investigation. I'm not saying that he didn't, but it didn't rise to the level under 16-7.3. If the administrator finds that any provision of this chapter is being violated, he shall send a written notice. Mr. Rothrock never found that. Mr. Rothrock relied on a violation or a complaint to create his violation, but it wasn't a written complaint as required. They don't tell us when it was. So we're really flying blind. Yeah, I've got a defense. I'll go anywhere without a defense. But that doesn't matter at this point. We have to put on notice.
of exactly what it is you're alleged to have done, when you're alleged to have done. And that's not here. The ordinance and the statutes set up for due process. It's just in this instance, it wasn't followed to the T.
It's a voicemail as written, because I left voicemails.
Hold on, Mr. Ransom, we're gonna get to you in a minute. We're gonna get to talk to all of us, but we got that one at a time. You would agree that Mr. Ransom's report, his words to Mr. Rothrock, you would agree that's evidence. That is some evidence, is it not?
It is evidence, yes, sir.
So before we turn to whether they met their burden to establish a current violation of the town ordinance, sticking with the paperwork, the sufficiency of the paperwork. What's your position on the sufficiency of the paperwork? It's inadequate.
It is inadequate to meet the constitutional burden of due process.
Okay, and what remedy do you want?
The only remedy that is sufficient when the constitutional violation, when there is a violation of due process, which that is protected by the Constitution, but U.S. and North Carolina, is the dismissal of the action. And then, you know, it may end us up back here, it may not. I don't know that. That would be foreseen, looking in the future, but they have to get their ducks in.
Let's speak to that.
So we can all waste our time, go home and come back next week, and they continue doing this.
No, just
I
hold
mean,
on.
this is just a waste.
Hold on. There's no saying, be careful what you ask for, because if we dismiss this because the notice was improper. Yes. Looking back, Myers, if they have been illegally rented short term, they'll get their slate. Looking back. Going forward, starting tomorrow, if Mr. Rothrock catches them and they make illegal short-term rentals, he develops evidence of that, he's gonna spin this right up again. I assume you have every right to.
Yes, sir.
So you're asking for a dismissal of the case, which will stop it right now. Now, before you put up any. Do you want to do that, or do you want to try to establish grandfather?
Well, I would still have the ability to establish grandfather.
Not here you want. If we dismiss this case, it stops.
Yes, sir. Yes, sir. I understand that. But if they rent, what I'm saying is if they rent again and Mr. Rothrock violates them,
Start all over.
and we appeal it, then we would still come in, and if we had the grandfather defense, we could present it. We also had the ability to go apply for, my class, assuming that dismissal was granted based off it, would have the ability to go apply for, with Mr. Rothrock, the grandfather permit, and he could choose to deny it or choose to, based off what we showed him, grant it. And then if he granted it and rentals continued or started, then this would, then it wouldn't come back.
Okay, we talked about the letter, the notice. We talked about the administrative appeal document. We haven't gotten whether they've established a violation, what they put up. Mr. Ransom, you've heard what we've been talking about.
Yes, sir.
Do you have anything to add to this?
In regards to what?
Whether the letter is sufficient to put them on notice, the Mars on notice, of
I
what
think
they
it's
did wrong and when they did it.
Basically, this all, to my knowledge, started back
Now, you have to talk to the letter.
after the letter.
Yes.
Well, the letter is a result of the voicemails that I left Kevin and the conversations that Kevin and I had on.
Indirectly. The question is, did he put out information?
I believe it. And you're either doing it or you're not. And you can go round and round and come back tomorrow if you want.
Mr. Barber, you have anything you want to say about the letter and the type of administrative appeal, they're at a disadvantage, you don't have to do a copy.
That's okay. It sounds to me that it's just technicality, and I understand due process, and certainly everybody deserves that. But here, this is the town hall, and we're not in the Supreme Court, and we all know what's been going on.
Talk about the letter, that's all we talk
So
about.
I think the letter states what was going on, and notified him, and anybody with reasonable intellectual ability would know that it's recent, it's not 1982, it's something that happened recently.
We all lawyer up, I can go get mine done.
Members of the board, we've been talking about whether the notice violation is sufficient. Before we get to whether the town has presented enough evidence to establish that the Myers were making illegal short-term rentals, let's talk about the letter. The Myers want this case to be dismissed. And we dismiss the case, and if we take a vote, I don't do that on my own. If we dismiss the case, if it pass, they get their slate on. Case stops right then and there tonight. And they're still in R15. And if they start doing illegal short-term rentals, Mr. Rothrock, we develop sufficient evidence to bring it. Cycling again, give them a notice of violation if they appeal the right back. Yeah. We got to do these cases appropriately. We got to do them fairly. We got to follow the law. Their arguments, Mr. Mosley makes a good argument. Mr. Miller makes a good argument. Talking about the letter. The letter is informing these people that you're violating the law. Is what they put in the letter sufficient to give them notice of what they have to defend? Yeah, I know they answered in their appeal document that they think is their grandfather, but they still deserve due process, a fair process, and a fair notice of what they're being charged with. I think at this point, we need to decide, is the letter sufficient? If it is, then we'll get to the question of whether they have put up enough evidence for Mr. Rothrock to establish a violation. In which the burden shifts to the Myers to show why it wasn't illegal. Is there any discussion on what the final notice of violation, whether it gave them sufficient notice of what they did? Violated the law, and further discussion. This is a tough one, I grant you.
I think the letter shows that we did something. What you said, you established that.
When you're talking into that,
I think the letter establishes the fact that the violation has occurred or has been brought up by multiple neighbors. And Kevin, I don't know whether there's a standard protocol, but took this information and generated a letter. So I think that it suggests that there is a violation. It says you may have, okay, it doesn't actually accuse them. They're here to appeal. The fact that they're appealing this suggests that maybe there is something. If they weren't doing something, they should be doing. Why would they be illegal?
Mr. Stevens.
I'd like to ask a question.
Yeah, what you think about the letter? Is the letter sufficient notice of what they alleged did?
In the testimony of those the ransoms and farmers,
But we have to look at it just at the point of the letter. It's like- At that
There's
point-
another, but he wouldn't have written the letter.
No,
Would,
no, no.
would Kevin have written the letter? Would he have written it without sufficient information from the people that are complaining? Would he have done it? Or does he just wake up one day and say, I think I'll write the Myers a letter and tell them that they're in violation? No, he received some information. Now my question is, how? I heard letter, I heard voicemail. I didn't hear a letter, I heard voicemail.
Conversations.
But my question, did you ever call the Myers and tell them that what's going on in that house bothered you? And not only that, that you saw people from out of town?
Jimmy, you got a pretty far field now.
Now, hang on.
Did you ever do that?
I want to respond to that. I've been trying to meet them. I've been trying to meet the Myers since I moved in the house. And the reason I know this is going on
My
is
question is, did you ever try to call?
I don't know their number. I go by their
Okay.
house, and try to see them, and all it is tenants.
All right, now we'll get back to the.
I keep asking people I see, are you my neighbor? No, I'm renting, is what they tell me.
Okay, let's get back to the.
Let's,
To me, the word may is troublesome. It's not being. Definitive.
I think he's not presuming guilt, when he says no.
all right, the Myers and Mr. Miller have asked for dismissal because they feel like the final list about violation is insufficient. Does not apprise them sufficiently of what the Myers are supposed to have done wrong and what they're supposed to have done. Do I hear a motion? Do I hear a motion from a board member, any board member, that the final notice of violation is sufficient to put them on notice of what they did wrong? You want to make that motion?
The violation is sufficient.
Ms. Murphy has moved that. Do I hear a second?
Second.
Second. Any further discussion? We're voting on whether the final notice of violation dated August 3rd, 2020 is sufficient to put them on notice, gives them sufficient due process. All those that think it is sufficient, say aye. I say no, so we have 3 ayes, we have 1 no. So the finding is that the final notice of violation is sufficient. Now, Mr. Ransom, did you have anything else you wanted to say at this point?
I just was gonna clarify that I had tried to meet the neighbors like all year long, and that the reason I know that the rental's going on is because all the tenants are telling me, yeah, we're renting.
All right, well, you're gonna get to testify later. That's good stuff. When you testify, just hold your fire. Mr. Marvin, do you have anything, Mr. Moses, do you have anything at this point? Get ready to go to the town has established violations. Anything on the letter? Mr. Miller, you heard the board's ruling on the letter. You ready to move to whether they've met their burden to establish violations?
Yes, sir. I have no comments on the letter. I respect the board's decision. No, I disagree with judges all the time. But as to do you want me to
Speak to whether they've met their burden to establish a current existence of a current town violation? Have they met the burden?
They have not for 2 or 3 reasons. The first reason, by the very wording of their ordinance, 16-7.1, received a written signed complaint alleging a violation of this chapter. That has not been met.
They haven't produced that letter because no letter exists. I know through some, I'll call it testimony of an intervener, it was via voicemail. That is not a written communication, which never, that I know of, found that to be a written communication. The statute is, or the ordinance in this case, is clear that it is a written signed complaint. I understand that 16-7.3 says if the administrator finds that any provision of this chapter is being violated, he shall send a written notice to the person responsible. We heard testimony from Mr. Rothrock. He didn't find that. He went off what Mr. Ransom said and sent the notice. And even in his notice itself, it says you may be violating. This is a charging document. Again, you have to be placed on notice. If you're placed on notice, and we pick up criminal warrants, it says on or about this date and time, so-and-so did embezzle money. It didn't say might have, it's did. Here it says may. So based off the information that the town presented, I don't think they met their burden to find that there was a violation. If he found renters there, gone out of the house and found renters, sure. If he found something on Airbnb that said they were renting it, sure. But so one, they didn't comply with their own ordinance, and two, there was no evidence other than one complaint that was not written.
That's your pronouncement on whether they or not they have met their burden of showing the existence of a current town violation.
Yes, sir.
Mr. Mosley says 16-7.1, receiving a written signed complaint doesn't preclude other methods of communication, doesn't preclude an oral communication. How would you address that?
I would agree with Mr. Mosley that it doesn't preclude it. Mr. Rothbard could have engaged in a further investigation. And again, this is nothing against Mr. Rothbard. He went to the computer and looked whether this software, whether it was a part, whether the software could catch illegal renting, short-term rentals. It didn't. He didn't go out to the house. He didn't. That was the extent of his independent investigation. So he didn't establish anything by that independent investigation. If he'd gone out there, and again, he's got a million things to do. This is not, I don't mean this as a knock on Mr. Rothbard, but just in this case, if he'd done a different investigation, maybe he would have found that there were short-term rentals, maybe he wouldn't have, and we wouldn't be here. But based on what we got, 16-7.3, he didn't find anything. In his own letter, he said no, which differs from did find. If he had a written complaint from Mr. Ransom, then he would have that and be able to act on it. But he doesn't have a written signed complaint.
I can imagine why he doesn't. This rental thing's being obscured because it's some
Mr.
sort of,
Ransom, yeah.
I'd just like to say it's some.
No,
kind of
you
pool
don't
arrangement.
get to pipe up whenever you want to now. You'll have to speak your piece, but you gotta wait. It's not time. All right, this is the chair's call. And I find that the town has met its burden to establish a current violation, a current town violation. So now the burden shifts to the Myers, and Mr. Miller can proceed with their case.
And I'm fine proceeding, and I'm not trying to quibble with your.
No, I want you to say everything you feel like you need to say.
So what statutory language allows the chair to make that unilateral decision, knowing that that will probably be the decision of the board, as opposed to the board voting as to whether they met the burden or not?
It's a tradition, and it's also, our local rule of chair rules on litigation.
Okay. Fair enough. I am. We would call Elizabeth Myers. Where would you like Ms. Myers to sit?
Wherever she is most comfortable. I feel like Mr. Ransom and Mr. Barber weren't very comfortable up there. Do you want to stay there?
I would love to be able to face everyone.
Is that all right?
Sure. Wherever your funds come.
I'll tell you what, you can get another chair. I'll take one up here if people are gonna come up.
All right? Okay.
Ma'am, please state your name
Elizabeth Maderas Myers.
and what address do you reside at?
I live in Charlotte at 220 Altondale Avenue.
And have you always resided in Charlotte or have you resided other places?
Other places, but Charlotte mostly.
What is your connection to 178 Norwood Circle in Blowing Rock?
Currently, I own a home. It's the house that my grandfather built. And it was passed to my daddy, Bill Maderas, and then I purchased it from my dad with the help of my ex-husband, Charles Myers, who's sitting beside you.
Okay. So just so we're clear, y'all are no longer married.
Correct?
Okay. But you both still have an ownership interest in the home.
Yes.
So I guess y'all get along to some degree.
Yes.
So do you know when the home was built?
Yes, it was completed in 1941. The land was purchased in 1939.
And what kind of home was built? What kind of home is this?
It's a, I'm.
How many bedrooms, square footage, do you know any of that?
Oh, gosh, no. Five bedrooms. I don't know the square footage. I'm sorry, I'm not good at that kind of thing.
That's fine. So
5,000.
do you know how the home was, did your grandpa live in the home?
It was a summer home. It was very typical of the time where families would go in the summer to get away from the heat of the city.
You say families, was it your family or other families?
Well, my family and then their families, their brothers, sisters, uncles, cousins would also come, and it's a wonderful house.
So people who didn't own the house and didn't have an ownership interest in the house would come and stay.
Oh, yes, absolutely.
Which I realize the town didn't define this until 2000 as a short-term rental. But do you understand what a short-term rental is under the town's definition of 28 days or less?
I think I understand that.
To your knowledge, did your grandfather rent the home out during his ownership period for periods of less than 28 days?
Yes, he did. My father did.
Okay, we'll get to your father.
Okay,
We're sticking to your grandfather right now, if that's all right.
Sure.
So your grandfather built it in 41,
Yes,
and when did he pass it to your father?
1965.
1965. So from 1941 to 1965, what is your knowledge base as to whether there were short-term rentals in the house?
There were a couple of letters from my aunt, not my aunt, his aunt and his sister that talked about thanks for using the cottage. They called it the cottage. But I don't know if any money was exchanged at that point. So maybe rental is the wrong word for that. They would lend the house to family and friends for my granddad, because it was only a Sunday.
So, but you don't know, well, I don't know what you know, but do you know whether the ordinance requires that money be exchanged for it to be a short-term rental?
I don't know that now, so.
So in 1965, your dad inherited it,
Yes,
and for
I hate to ask this, but what year were you born so that we can?
That's all right. I was born in 1962.
Okay. So your knowledge base, from what happened prior to 1962 and probably even a little bit later than that, is based from those letters and anything else?
I'm sorry, I don't understand.
How do you gain your knowledge about what the use of the house was
Oh,
prior to, you being able to comprehend and retain knowledge, or being born? Where did you gain that, or was it just from those letters?
letters, family, talking about it. When my daddy would spend the summers there, so we would talk about playing Army and using the bathroom off the balcony, so you could go to the bathroom furthest. I mean, silly little things. Sorry.
Was there maintained in the residence a guest book?
Yes.
Tell us a little bit about that guest book.
We have an early guest book. I guess it starts in the 70s and continues on, where we have friends, family, people that rent, write in the book what a nice time they had or what happened, weather good, if they saw a bobcat, fun stuff.
So your dad, what's his name?
William Fields
Where's he reside?
in Charlotte.
And he owned the home from 1965 until when?
2017.
And how old is your father?
He turns 88 tomorrow.
And so he wasn't able to come and testify today, right? Mr. Chair, I have a signed affidavit from William Virus. So I didn't mess it up. It is my understanding from consultation with Mr. Moser that you don't care much, that you would rather have live testimony than affidavit testimony. And I understand that, respect that we can possibly call him if it went later than what we anticipated, but there might be an ability to call him as the next witness if you were inclined not to allow him to be called pursuant to 168-393 subsection, I believe it's K, the competent evidence.
Let me ask you a question. Is it sworn, is it notarized?
It is notarized, yes, sir.
No. Members of the board is not. Allow you to put your recollections. Yeah. We went around and around for a while. So what's like your appetite? Who do you want to coach? Who do you want to read?
I have Ms. Medeiros, or Ms. Myers read it, if that works.
Whatever you want to do. Let us know how you want to get it in there.
Would you like me to have her read it and publish it first, or would you like me to hand out a copy to everybody?
Let's get it.
I'm hoping, I made 10 copies, so I'm hoping. So, Ms. Myers,
Yes, sir.
is this affidavit that you and Mr. Myers procured from Mr. Medeiros?
Yes, it is.
Is that a signature on the last page?
Yeah.
And that's a notary stamp below
Yes,
it. So, just starting with the first paragraph, first note, well, can you just read it for us into the rest?
sure. My name is William F. Medeiros Jr. I am over the age of 18 of sound mind and body and under no undue influence. My father, William F. Medeiros Sr., built our family mountain home at 178 Norwood Circle, Going Rock, 28605 in 1940. This home has remained in our family since 1940. I inherited the home along with my sister, Mary Ann Troutman, in 1965. Since 1965, we have consistently used the home as a second home, and we rented the home out for short-term and long-term rentals as defined by the town of Blowing Rock. My goal was to do a short-term rental every month in order to offset expenses. It is also important to note that my sister, Mary Ann Troutman, also provided the home to her contacts for short-term rentals as well. In some cases, we charged rent, and in some cases, we allowed friends and others to stay in our home for short periods of time without paying rent or in exchange for it. We have continuously done these short and long-term rentals since 1965 in order to help pay the taxes, insurance, and upkeep on the property. There has never been a gap where we did not rent the home during a 6-month.
So since you have been alive and knowledgeable of the home, how would your dad and aunt rent the home with you?
Mostly friends. People would call, they would hear about the house and call and ask if it could be rented. We've had several artists. At one point, Ben Long was going to stay when he did the paintings in the church here.
So I don't know who Ben Long is. Can you tell us who Ben Long is?
Yes, he does frescoes. He's very noted for his art.
You know when that was?
I'm gonna guess in the 80s. I'm really not sure.
So, were there times that you wanted to use a home where it was occupied with non-family members that were essentially renting it?
Yes.
While your father owned it, did you keep a record of who rented it and when?
Only through the books, the guest books.
Did everybody write in the guest book?
No, it was up to them if they wanted to write in it. No.
And so, do you recall a time from when you can remember until you became an owner of the property in 2017 where there was a 6-month period that it wasn't rented, a short-term rental to somebody? Was there ever a time from when she can first remember until she owned the property in 2017 that there was a 6-month period that you know of where there was not a short-term renter in the residence?
Not that I mean, it seemed to be constantly used. I think it's always been used. I mean, there were many times when I was told, you can't go out this weekend or whatever.
And just so that we're fair to everybody, you can't know that 100%. I'm just asking if anything comes to mind.
Right, you're correct about that.
So you like to keep family records.
Yes.
And you wanted, I guess I should mark this affidavit appellant one.
Yes, and then,
And I guess I would formally move to introduce appellant one into evidence.
Mr. Mosley, do you object to that?
To the affidavit.
Yes.
I don't object to having it admitted. You know, we can argue or talk later about whether it's substantial competent evidence.
Mr. Ransom, do you object to the father's affidavit being part of the record? So that we can consider what he said. Mr. Walker, do you object? So it's going to be part of the record. You would call appellants exhibit wherever you are with your exhibits.
I'm at one.
And then I'll report to you.
May I approach the witness? Well, I guess before I approach the witness, you keep, you're a purveyor of family history and keeper of some records. In your record keeping, did you find a letter from to your father that's handwritten from somebody, and I can't read it? Did you, I guess I ought to show her what else to. You might want to show her this, to see if she can recognize it. You mind if I show it?
You can show it to her, but we're going to talk about it. Bringing in a letter with it's hearsay.
Yes, sir. Showing you what's marked. Applicants, appellants too. I'll get the name right. Do you recognize that document?
Yes.
Okay. And how do you recognize that document?
I was sent to my mother. Talking about the mountain.
Okay, don't tell us what it's talking about. Just yet. It was sent to your mother from who? I approach with the actual letter itself.
Yes.
I'll see her monogram.
I'll show you the letter envelope itself.
Oh, yes. This is my,
Well, just tell us the name.
oh, sorry, Mrs. Ben Horton.
And what year is the report, is this document reportedly sent?
1973.
And where did you find said letter?
My entire family, everybody just gives me everything, and I'm like the archivist, so it was given to me by my parents.
So, and appellants two is a handwritten letter from that Miss Horton to your mother,
Yes,
and it references the county,
yes, the college,
or the college.
yeah.
Before I get into the potential hearsay, I wanted to address the board, Mr. Chairman, to alert you that that is where I'm heading at this point. I'm offering this for what value it has. It's a 1973 letter from two parties who, is your mother still alive?
Yes.
Okay. So I guess theoretically we could get an 80-plus-year-old lady up here to authenticate it. Do you know if Miss Horton's alive?
I don't believe she is, no, she's not.
It does not go, well, it's only hearsay if it goes to offer the truth of the matter asserted.
That's correct.
And it does make reference to tenants at the cottage. So it would be up for y'all to decide whether it's the truth of the matter asserted or whether it meets a hearsay exception. It is an older document.
I'll tell you now, it's hearsay. You didn't have any hearsay exception.
The hearsay exception that I would have is that it references a cottage. It's
The cottage is a short-term rental business, and this would be a business record duly kept in the normal course of this business.
Who's gonna authenticate?
Well, she's now the owner of the business and the keeper of the records.
Is the writer of the letter still alive?
She testifies she does not believe so.
Mr. Mosley, what's your position?
On topic to look at before you take a position. They're part on the same pages.
You object to the letter, Mr. Mosley?
I object to the letter.
Okay, very good. Mr. Ramsey,
Yes,
do you object to this letter written in the 1970s?
I do. It seems ridiculous.
No, you don't need a political commentary, just.
Yes.
Okay, you object. Mr. Barber, do you object to this?
The only other comment I'd say in regards to it, Mr. Chair, is that due to the length of the ordinance itself, it makes us go back very far in time to prove something, because the burden is shifted on us. I understand that it is hearsay. I get that. Hearsay is allowed in these hearings, but when you have, as long as it appears to be competent evidence, we have an ordinance that purports to date back sometime in the early 80s. I don't know if we got a specific date, maybe it was 84. And so we're having to reach back and find documents prior to the 80s to prove that this was a short-term rental. I mean, we're attempting to do that with the documents that we're having with the change in hand. But, you know, inevitably there's going to be some hearsay items before I make up.
Can I see a copy of the letter?
Yes, sir.
All I got. Carry through. 807. I forget that I'm on live.
Is there another page?
On my approach, I'll give you it. So I guess there are pages that need to be copied. I guess the only relevant part.
You can have it. It's here, so it's not.
Yes, sir. I would like to leave a copy with the clerk for the record.
Sure, it's full copy, sure. Yeah, protect yourself.
Well, it's the only copy I got. If I can supplement the record later by making a full copy of the letter that it exists in that.
Ron, the file in this case, it lives in your office, is that right?
Yes, it's right here right now.
Well, he's gonna mail it to you later, so that's who you're
Yeah.
gonna mail
Yes, sir.
And I just need to make a note that I need to do that.
We keep up with what's been submitted.
it. So, no, we do allow.
We keep up with what's
phone in. So just tomorrow,
Okay.
phone, just- just a while. Cases continue. I don't think we're gonna wrap this up.
Yes, sir. I agree, and I appreciate that. With the, I guess the board, would it prefer phoned in or would it prefer Zoom, or does it matter?
Just so we hear and they take the oath. Either one.
All right, Ms. Myers. You obtained ownership in 2017. Why did you buy the house?
It's very special to my family. Legacy, heritage, all of that's very important to me, my family. A lot of special things have happened there. And my daughter, our daughter, will be fifth generation, and she inherits it. I'm fourth. It's just very important. A lot of local people built the house, which I admire. A lot of the furniture inside is local furniture. A lot of things have been celebrated there. Very special.
Was there an economic reasoning behind buying it as well, or just all sentimental?
Sentimental, do you mean, are you asking, would I make money off the house?
Did you pay for the house?
Yes.
And you and Mr. Myers paid for that? Right?
Yes.
And what did y'all pay in 2017, if you recall?
800,000 something. 880 something.
I would represent to you, deed stamps on the deed say $1,700. If you do our little formula, that equates to a purchase price of $850,000.
Okay.
Does that sound in the neighborhood of what you spent?
Yes.
So, did you talk with Mr. Myers about ways to afford the house?
Yes.
And what were those conversations?
In a nutshell, that we needed to rent the house to bring in income, to pay taxes and a mortgage and upkeep. And then when our friends asked to use it, we asked that they help us out by paying something.
Okay. And so, with your friend, I mean, was that something you and Mr. Myers came up with before you purchased the home or after you purchased? Or do you recall?
I'm not sure.
Okay. Who handled, did y'all form a business in regards to this, an LLC or something?
Oh, yes, we do have an LLC.
And in regards to that LLC, who's the member manager or controlling member?
Charles.
Would it be better to ask you the questions in regards to the finances of the LLC or him?
Charles. Yes.
So after you bought it, did the vacation rentals or the short-term rentals continue?
Oh, yes. All our friends are very excited. Family was excited, yeah.
And so at any time since you've owned it, from now, looking back to 2017, was there any period during that time, a 6-month period, where there were no short-term rentals? A continuous 6-month period?
No, someone's always using the house. I don't think there was ever a lull. And whether it was family or rentals or friends, somebody's always wanting to use the house. It's very special.
And so, and given the location, the house has a magnificent view.
It does.
So at the time, at any time, we'll start that. How often do you come to Blowing Rock?
I probably average once a month. More if I have the opportunity, but I work, so.
So in regards to at home, do you take the Blowing Rocket, or the Watauga Democrat, or any of those papers in Charlotte?
The newspaper, no.
Prior to the notice of violation, had you ever heard of a short-term rental ban in an R15 district?
No.
So nobody had ever brought that up to you, whether it be a town member or Mr. Myers or your dad or?
No.
So the rentals, when you were doing the rentals, did you have any reason, and I understand that ignorance of the law is no excuse, but did you have any reason, any knowledge that you were in violation of the ordinance?
No, I didn't know there was an ordinance to say that I couldn't do that, so no, I apologize, but no, I didn't know.
So how do you advertise, since you and Mr. Myers bought the property? How do you rent it?
Until recently, it's just hearsay. It's just friends connecting, family connecting with friends, usually people we know. Until recently, we have the thing with Evolve, and then it's called Evolve, EVOLVE, is that right? Sorry?
Is the website Evolve.com?
I don't even, is it a website? I don't know. Sorry.
I'll represent to you that I am going to put in on the test bus.
He handles all that, I apologize.
That didn't happen until after this notice of violation, that he put it on the Evolve.
Yes, I'm pretty sure we asked Kevin if it was okay to do until prior to this hearing. And you said it was fine because we already had some people lined up.
What was that question? I didn't.
It's whether they put Evolve, whether they put the property in the Evolve, whatever that program, I don't know what it is either. After the notice of violation.
Oh,
during the state.
after. Oh,
She's saying she asked you though.
they asked if they could continue to rent once the appeal application was filed, and I said yes, because that stays any enforcement action by the town. So I couldn't stop them.
So, but prior to that, prior to the notice of violation, have y'all ever advertised it on the internet?
No, we're also part of a program called Third Home. And it's throughout the world, but they don't pay. You'll have to explain it better than I, Charles, but basically people can come and stay in your home, and you as a member of that third home can go anywhere in the world and stay in another home.
And how long, is that advertised over the internet?
I don't know how that works.
Okay.
It's
So-
through one gentleman, I believe, just one. Oh, okay, he'll tell you.
Okay, all right. Okay. If you don't know, you don't know, and that's fine. We'll get to him. Not tonight, but some other time.
Okay.
So, you don't know about one home or the, whatever that is, where that's advertised.
Third home.
Third
Yeah.
home, third home. You don't know if that's internet-based or not, right?
I would assume it is, but I do not know.
Do you know if the home is advertised on Airbnb,
No,
VRBO?
no,
Do you have a rental agency?
no.
So other than that third home, there's been no independent advertising, other than word of mouth?
But yes, it's just word of mouth. Yeah, gossip, yes.
And are there, I believe that was, pass it on.
Mr. Moss?
Let me, make sure that I understand. What time are we now?
I've got
8:20.
Okay. Let me make sure I understand the ownership history. I pulled some deeds from the Register of Deeds office. So, as I understand it, the property was acquired by your grandparents in 1939.
Correct.
And according to the deed, and I'm reading from the deed, it's not like I've gone on some great discovery mission here. The deed states that your grandmother died in 61 and your grandfather died in 65. And I gather from the affidavit that when your grandfather passed away, he left it to your dad and your aunt, whose name was Mary Ann Troutman. So they owned it half and half.
Yes.
Okay, and then they each apparently transferred the titles to their 1/2 interest to entities. Your dad to something called Madeira's Properties Limited Partnership, and your aunt to something called Mary Ann Troutman Family LLC, correct?
Yes.
And so, who were the members of those entities? Who had ownership interests in those entities? Starting with Madeira's Properties Limited Partnership.
Who had ownership in the house?
Who had the ownership interest in that entity, the limited partnership?
Well, I guess it would just been my dad and my mom.
Okay. And if you don't know, that's fine, I'm just asking. The Mary Ann Troutman Family LLC, who would have had an ownership interest in that?
My aunt.
Your aunt.
Mhm.
Okay, and so according to the affidavit that your dad signed, he states in his affidavit that both he and your aunt engaged in short-term rentals of the property.
Yes.
Do you have any knowledge as to whether they kept records of their rentals?
I don't have knowledge of that.
You clearly don't have any records.
No,
Correct.
I have a guest book or two.
Okay, so you have a guest book, but you don't have any records of any rentals.
No, sir. My
Indeed.
father couldn't find any of that.
So do you have any knowledge as to whether they, as to what percentage of their guests were renters and what percentage were just friends who stayed there?
I apologize, I do not know that.
And so the guest book that we're talking about, would that be a guest book that went from what period to what period? What would be the dates of entries in this guest book?
I believe we have two, and I believe one is in the 70s, 1970s. And then there's another, I believe is, I'm not sure when it begins, but it's very current, 2020.
So you've continued the guest book.
Oh, yes.
So the guest book would be something that was maintained by your dad and your aunt?
Yes.
Okay, and they maintained it until 2017 when they sold the property to you?
Yes, sir. It's just something that just sat in the house. So I guess it's actually a place where it goes.
Okay, so you have that guest book. You're introducing that. You didn't introduce it, but you're going to introduce it. I guess that's a question for your attorney.
We're gonna introduce it. I'm gonna introduce it with a different witness.
Okay, well then we can get to that when we get to that. So you stated that you formed a business. You formed a limited liability company.
Yes.
But now the ownership is with you and Mr. Myers, correct?
Yes.
So you own it individually. And so the limited liability company that you formed, what's the relationship between the limited liability company and you and Mr. Myers?
I have no idea.
Okay.
What your
Question for Mr. Myers. So you stated that there's never, let me back up, I'm sorry. From the time you acquired the property in 2017 until now,
Yes.
what percentage of occupants during that 3-year period have been paying rentals, and what percentage have been people that were just friends that didn't pay rent?
Goodness. I would say, I mean, this is off the top of my head because I wasn't prepared for that question at all, but I would say probably 60%, 70% paying something.
Paying renters. And
Yes.
so do you, when these people, and these people are not all people that you are just friends with, correct? Some of them you don't know, you don't have a relationship.
That's correct.
So do you have rental contracts that you enter into with them?
Not that I know. It's all,
I think she's mixing them. You can't.
sorry. I mean, I'm sure through the companies there are, but when it's a friend or a friend of a friend, they just give us cash.
So what I'm asking about are people who are entering into a short-term rental agreement to use the house, do they sign a rental contract? They do.
Yes, I do. I'm not the business owner. I apologize.
Let's stop there, Mr. Mosley. We're gonna be continuing your calls when we resume. Let's talk about a continuation date, because about a month from now, around Thanksgiving, very
Perfect.
problem in the year.
Perfect.
What would the third Thursday be? Do you have a calendar?
I do.
And when is Thanksgiving?
It's the 26th. The 19th, I've got planning board. So if you want to look at a Tuesday, either prior to that or the 24th, I mean, I know people take off Thanksgiving week, some of them, so it may be tough.
Let's talk about Tuesday before.
17th,
17th. If we did it Tuesday night, the 17th, starting at 5:30, anybody can talk to the board members, Mr. Ransom, Tuesday night, November 17th. Do you know of any conflicts you have if you be out of town or whatever to where you can't attend?
I'm just driving up from Charlotte, probably I'm scheduled for some arm surgery and, but if I can't make it, my wife will make it. But that,
Does she know what you know?
yes,
Since he's a party, I don't think that works. I mean, I'm not objecting necessarily, I just am saying.
I don't know when the surgery is. They're having a piece made for my arm. That'll help them with the surgery.
Okay.
I was over there.
Anybody else know of any problems with Tuesday night, the 17th?
I'll let you know.
I don't have a problem. Mr. Mosley,
No
as
problem.
far as you know, Mr. Rockoff, is your
I
calendar?
better start at 2 o'clock.
I am, I'm working,
I better start at 2 o'clock.
On the Wi-Fi, but I'm free.
We're gonna,
Elizabeth, you okay with something?
I would have to see my calendar.
we're gonna make this.
EB, I got a suggestion for, maybe we consider starting a little bit earlier. I mean, I know, depending on whoever is working, but I just know how it can go. If you wanted to start at 4 or something like that, we're not locked to 5:30, but that's y'all's choice.
I understand.
I have a mediation that day, in Cova, I don't know if it's Cova or Cova at this point, case, so I can make 5:30. And other days I can start early.
Let's don't get too big. Let's make this a pretty firm date, but a little bit tentative. And we're all gonna check it, and we're all gonna communicate by email. And as long as we're emailing about the date of the hearing, nothing else, if Mr. Miller emails me, that doesn't copy the town, and all he's talking about is the date, has anybody got a problem with that? As long as it,
I would copy the town.
well, Mr. Barber, Mr. Ransom, you need to get Mr. Rothblock your phone number and your mailing address. And then he needs to know how to get in touch with you, your email address. And we'll follow up over the next week or so, just to kind of double check after everybody's checked their calendars and everything, that we can do this at 5:30 on November 17th. We'll probably be back over in Town Hall. I hope so.
Yeah, I hope so. I think we will.
You think the election will be over by then?
Well, he won't get to vote again, so whatever.
Sure. So I would entertain a motion to close the hearing for tonight. We're going to continue this case. Anybody have such a motion? Mr. Steele moves it. A second. We got a second from Ms. Lund. All members of the board that want to conclude this hearing for tonight, continue it, and go home tonight and say aye. Aye. Everyone have a good evening.
So I need email